You may be seated. This time, State, you may proceed with your rebuttal argument.
Thank you. Before I get started, there's a couple things I want to reinforce to you. The first is that what the lawyers say is in evidence. And that's a good thing, because Mr. Dowdy was listening to a different trial. Mr. Dowdy's characterization of the testimony of the witnesses was inaccurate and misleading. And I tell you that so that when you look at your notes of his closing argument, that you take them not with a grain of salt, with a 50-pound bag of it. Not once in his closing argument did he say, look at the evidence, don't take my word for it, review the evidence, not once. Not once did he say, review your notes, because your memory is the memory that matters. Not what Mr. Dowdy says, and not what I say. So keep that in mind. Basically, to sum up the hour of closing argument that you just heard, the defense is everybody's a liar and everybody's incompetent. Why? Why is that the defense now? Because in opening statement, no access to firearms, treacherous, I forget the word now, mixture of guns and ammo and drugs, no physical evidence. The state of Florida, through the course of their case, maintains the duty and welcomes the duty to prove the case beyond a reasonable doubt. And in this case, we dismantled every allegation in a part of the trial that's not even evidence. Remember that? The evidence is only in the middle. So that's why today's version is everybody's a liar and everybody's incompetent. I know to you it's a gruesome, disturbing scene. No one here is trying to shock you. But unfortunately, or fortunately, depending on your persuasion, the state has the burden of placing forth evidence that sometimes is gruesome and disturbing. We don't do it lightly. We don't enjoy putting those images in your head. Those are the images that we live with. But sometimes we have to. And I'm going to tell you that the scene at 2112 was actually not a bloody mess. Let me tell you why. The blood that came from Margaret Amato was localized to the area under her desk. That's it. So unless Gran Amato was going under her desk, rolling around in her blood, he's not going to get any of that blood on her. The blood that came from Cody Amato was localized to a door. Again, it's very easy to not get blood on you if you step over a body. The blood that came from Chad Amato in the kitchen, there was blood there. But the question is, could Gran Amato have totally avoided that area without stepping in that blood to accomplish what he had to accomplish? And the answer is yes. Remember that diagram of the house? The den's on one side, the office is on the other, the kitchen is in the front, and then you'll have a diagram. You can look at it yourself, and please do. You don't have to roll around and mess with that stuff. You don't have to walk in the blood. You know? That's not what he had to do, and he didn't do it. That's why you don't have footprints in the blood. So while it might be gruesome to you, it's not a bloody scene in the sense of the word that Mr. Dowdy was trying to emphasize to you. It's very easy to avoid blood in that house. I want to talk about each of these witnesses that Mr. Dowdy, during the course of this was impugn their character and impugn their reputation. Christine Snyder and Arthur Rubart. Spent 5 days at that house, processing the scene. Arthur Rubart was on the stand, I don't even know how many hours during this trial, doing his job. And shame on the defense for insinuating that he didn't. Arthur Rubart testified that nobody touched Chad Amato's body to process those fingers. Even during cross-examination. Sperm. Christine Snyder. If you recall that cross-examination, Mr. Dowdy yelled at her at the end because she wasn't giving in to the arguments he was trying to lay. You would say that, I believe, is what he ended the cross-examination with. Because she said, we're not in the business of destroying evidence. We're not in the business of manufacturing evidence. If anything's been manufactured here, it's been a closing argument. Danny Anderson. Oh, excuse me, the phone wasn't processed. I implore you to look at the photographs of Chad's iPhone. Yes, he was an organized person. But every single person has fingerprints on that phone. That phone has none. Look at the pictures. They're not there. That phone was wiped down by the defendant, cleaned off, because his hands were all over it. Danny Anderson. Danny Anderson spent 7.5 hours with a murderer trying to get to the truth. And Grant Amato did what he always did. I didn't admit to it. His words, not mine. Danny Anderson testified multiple times in this trial. And why? Because any time the defense attempted to manufacture reasonable doubt, the state has the burden to show why it's not there. That's why Arthur testified, Mr. Rubart testified many times, and everybody else. Don't hold that against us. That's our job. Mr. Dowdy said that Grant's story added up. Again, not true. Grant's story did not add up. Grant said he left the house the second time. Forget the lies in the middle of the interview, but let's stick to the second time. He left the house at 12 o'clock and he went to Publix Wi-Fi. You'll see on that map, Publix is close, 20 minutes. When was the first time that his computer activated the Wi-Fi network? 2:56 in the morning. 2:56 in the morning. Not 12:30. That's why I asked Mr. Troy Roberts from Publix. I asked him, was there any record of any other device accessing that Publix Wi-Fi that night? Just in case there would be any sort of inference that, well, the defendant used his iPad that he had, or the defendant used his iPhone that only has Wi-Fi. I wanted to eliminate that for this very reason. And we did. And so we know 2:56 is when he got there, not 12:30. That didn't add up. Let's go through, I believe Mr. Dowdy said that there were 2 lies that Grant told during the course of his interview. 2. So these are my notes. Actually, these are Mr. Stone's notes. And again, review your own and watch the video. Met with my brother before he came home. Lie. I'm not going to count it. You can count. I waited in the neighborhood area. Lie. I was on the back side of the house. Lie. Take the bend where it has those 2 blinking lights. Lie. Just down that road. Lie. It was just down that road. Twice he said that. Lie. I brought him, Cody, up to speed. Lie. I spoke with Cody. Lie. He had given me his debit card. Off the road, on the road. Lie. The last thing he told me is that he would take care of it. Lie. I met with Cody at 10 or 10:30-ish. Lie. After that, I stayed in the vicinity of the area. Lie. Met Cody way down this road, pointing on the map, down in the country area. Lie. About a mile. Lie. Off the road. Lie. Talk with Cody for about 10 minutes or so. Lie. He said he would take care of it. Lie. My mom brought Cody up to speed. Cody told me, and my mom spoke with him. Lie. I mean, that's not 2 lies. I don't even know how many that is. More than 2. So Grant's story doesn't add up. Unless 1 + 1 is 6. Mr. Dowdy told you the family was getting along. Grant was getting better. Left the facility. There was a 60-day stint, I believe, from the interview. He left 6 days into it. He said because there was nothing they could do for him. Why? Why was there nothing he could do for them? Maybe he didn't acknowledge he had a problem. Who knows? But we know he wasn't getting better. You know why we know? Because he wrote that apology letter. And you read it. It's not the words of somebody who's getting better. Everyone was coming together. That's what Mr. Dowdy said. Everybody was coming together, except for Grant. That's why he had to kill them. Mr. Dowdy intimated, I think he just said actually, that Ms. Farnell testified that Jason spoke to Chad Amato that night. Then he said, but she was sort of backing off on that. Well, that's also not what she said. She said on redirect that she, flubbed her words, and that's not what she said. Now, that's what he said, just now in front of you. But that's not what she said on the stand. Look to your notes, please. There is no record, deleted or otherwise, of Chad talking to Jason that night. And you have the phone records if you want to look at them. No problem. We talked about the scene being localized with blood. No blood on the defendant. He was in that house for at least 4 hours, maybe 5 hours, undisturbed, collecting whatever he needed to collect, throw it, bagging up whatever he needed to bag up. So of course not. No kidding. He had the opportunity to cover his tracks. He knows what blood is. He knows what DNA is. He's a friggin' nurse. Paul Schatz, Mr. Dowdy said Paul Schatz confirmed that Grant Amato went to the interview. That's true. He sure did. That is true. Paul Schatz also confirmed that Grant Amato drove back down Dean Road exit towards his house when he said that first he wasn't going to go. Then, I went, but I didn't see anything. And then I went, but I saw police on it. Yeah, so Paul Schatz actually was very useful. And he was straightforward. Geraldine Bly, not forthright. Mr. Dowdy's words. I would submit to you that there was no impeachment of her testimony at all. She was cross-examined vigorously. I don't know what she wasn't forthright about. I have some notes here. Let's see. Left out the fingerprint access on her spreadsheet that we went over. Remember that? That's what Mr. Dowdy said. Well, if you remember from your notes, that spreadsheet only contains information from the database files contained in the phone. Okay? And, if you remember from her testimony, Ms. Bly said that she wasn't able to get the fingerprint information off the phone, which is why we had to get the fingerprint information directly from USAA. It's not on the phone, we have to get it some other way, and that's how we got it. She said that that record contains what was on the phone. Now, let's talk about this argument that apparently everybody only uses their thumb on their iPhone. And I want to take you back in time to address that argument. When Touch ID first came out, and you are setting up the Touch ID on your phone for the very first time, I would submit to you that most everybody did this. They turn their phone on. Of course, mine has Face ID these days, but they turn the phone on, and they say, ooh, set up Touch ID, and you flip the switch, right? It says, okay, set it up. And then you realize you can set up more than one finger. And then you're like, oh, well, I guess I'll just do my thumb too. That's not unreasonable. That's normal. That happens. And who's to say what Chad didn't or didn't do? All we know is what the evidence shows us. The evidence shows us his fingerprint was used to access that phone, and his clean finger was this finger. And, by the way, not for nothing, if you look at the crime scene photo, not the medical examiner one where magically his blood was wiped off of him, but before all that fingerprint scanning allegedly happened, even though it didn't happen, we'll get to that in a minute, you'll see Chad Amato laying on his back with his right hand sticking out. And what will you see? His right finger sticking out further than all the rest. And what does that tell you? The defendant picked that finger up and put it on the phone. Look at the picture, please. There's a very good picture of it. We pick our photos for a reason. Then he mentioned, and I think he jumped over to Arthur Rubart about the hotel. At the hotel, when you turned on to the hotel and the screen was off, and Arthur Rubart said, I took a picture of the screen. And I believe the testimony was, and again, refer to your notes, that when he walked in, the screen was off, he took a picture. Another officer wiggled the mouse pad, or touched the mouse pad, and the screen came on, and then he took a picture, it was on the screen. That's called manufacturing impeachment evidence. In other words, trying to make somebody look like a liar when they're not. Like I say, go to your notes. Don't take my word for it. Cody's phone was, this is in Mr. Dowdy's words, Cody's phone was plugged into laptop. No. Cody's phone was plugged into Grant's desktop upstairs. That's what happened. And Ms. Bly was very clear that there are only two things you can do. And there's a reason why, and I'm going to tell you why. It's very clear. There are two things you can do in recovery mode. Wipe the phone, right? Or restore it. Or update it, excuse me. Restore and wipe is the same thing. Or update the phone. Update the operating system. Ms. Bly testified that you can update the operating system, and I'm sure we've all done this. By putting your passcode in, hit auto updates, and it goes over the Wi-Fi. Ms. Bly testified that those are the only two things you can do. Why does she say that? To prevent this. To prevent the inference that Grant Amato was using, that Cody gave him his phone so he could have pictures of his phone since he was leaving the house. You know, Cody said that I could have his phone and I could look at the photographs and take pictures of us from Japan or whatever happened. No. That's why she testified that way. It's not possible because remember the phones didn't handshake. They can't transfer data when they're not handshaking. That's why she testified that way. To infer that she did not do her job is not only a mischaracterization of the evidence you heard in this case, but an insult to the hours and hours and hours she spent working on this case, up and until and during this trial. Metadata in the pictures, again, mischaracterization. Mr. Dowdy told you in his closing argument that the inference that Ms. Bly was making was that those pictures were created that night, after everybody died. No. What Ms. Bly testified to was that those photographs were moved from Grant's computer to that thumb drive that was found in his pocket. That's what you testified to. And we have the metadata. And Mr. Dowdy mentions, why would there be a picture of an expired card? December 2018. Would you like to see the metadata on that particular picture? Because that picture was taken before the card expired. During the 6-month time period that he was blowing through $200,000. That's why the picture was there. Nicholas Stewart. Chad's phone searching how to bypass codes. That was the history earlier in Chad's searches. That's true. I can't say that's not true. Why, though? Grant Amato was on internet lockdown by his own statement, by the agreement that you're going to see. Grant Amato's equipment was Windows equipment. Chad Amato was searching for ways to keep his son off his computer. Grant Amato said as much in his interview. That's why he was searching those things. That's why they were earlier in January. Sloan Young. That's Sloan Young. I want to be very clear. My recollection of the evidence is that Sloan said, and by all means, I hope you took good notes, because now we've manufactured some facts that are not accurate. Sloan said that Cody called his dad, not that dad called. That was her testimony in court, in front of you, in front of us. And you don't even have to believe her. You don't even have to believe her. Because we have the phone records over my shoulder. Outgoing calls from Cody's phone the night of the homicide. M.O., M.O., M.O. Remember? M.O. is outgoing. 2 to Dad's phone and 2 to the house. The 2 to Dad's phone, remember the stipulation what Dad's phone number is, the cell phone number? 1 second and 4 seconds. That's not a pickup. 1,429 seconds, that's to the house line. That was the phone call that Cody made that Grant answered at the house, because everybody else is dead. So, Sloan Young wasn't impeached. You should believe her. But even if you don't believe her, there you go. Blake Turpin, the renegade witness, in the state's back pocket or whatever else he said. Blake was friends with Grant Amato for years, high school. Do you think it's easy for someone to turn on their friend and say the things he said? Same with Jericho? No, it's not. Mr. Turpin, despite Mr. Dowdy, who is a very skilled defense lawyer, very good at cross-examining folks, Mr. Turpin did not waver, did not vacillate, did not change anything that he said. That is the fact. Sloan Young said that she didn't even know if Cody talked to his father. Thank you. Blake maintains that the report that he made was filled out incorrectly. Mr. Dowdy said the gun was missing for a year. It's not true. 6 months was when the report was made. And Mr. Turpin said the moment he realized the gun was missing, the next day or that day, he called the police. So that 12-month number, I don't know where that keeps coming from, but it's not from the evidence in this case. Why? Why would he not have grabbed the boxes of ammo that were loose? Easy. This is a crime of opportunity. This was the only opportunity he had to be in that room, because Blake's a private person, doesn't let anybody back there very often. And what's closer? The gun over here with the bags over here, or you got to dig down below in the bottom of the closet, pull the drawer out, open up this ammo can, go in there. No. You grab the gun, you put it in your pocket, take the bag, and then that's it, and you're out of there. Crime of opportunity. Mr. Dowdy said that Grant Amato, they put forth evidence that Grant Amato pawned a revolver. That's that pawn shop fellow testified yesterday. It's true. He did. But that's great. Revolvers don't eject shell casings and they don't shoot a 9mm, so what difference does that make? And number two, the more that the defendant divorces himself from guns, the less believable the explanation is for the gunshot residue. It would be a much more difficult argument if the house was full of guns. But it wasn't. They were gone. What about the gloves? There's a picture of some other gloves in that cabinet. I don't know where the picture is. Doesn't matter. Let me tell you what. First of all, you have to assume that those gloves were stored in that closet. There's no evidence of that. Remember, it's based on the evidence. Second, you have to assume that they were placed somewhere on that foam insert. Well, guess what's all on top of that foam insert? All kinds of stuff. And of course, you have to assume that if the gloves are in there, he never goes in his closet. I mean, it's the logical jumps you have to make are impossible. Richard Ruth. This is a good one. Glock 17. He couldn't eliminate the Glock 17. That's okay. I can eliminate it for you. Piece of cake. Let's go down this road. Happy to do it. The Glock 17 found on Chad's hip could not conclusively eliminate it. Now, mind you, it's inconclusive with a negative sign right above eliminate. Well, forget about that for a minute. And I think he said it's not likely. But forget that. Forget it. How do we exclude this gun? Okay. Chad Amato went on a shooting spree. Right? It's his gun. So Chad Amato shot his wife in the back of the head. I guess after Grant left. Cody got home, and Chad Amato shot Cody in the face. And then Chad Amato killed himself. Crazy thing about suicide is once you put a bullet in your head, you can't put the gun back in the holster. That gun could not have fired. Dead people cannot reholster their gun and put the Velcro clip back on it. So there you go. I'm not an expert, but I've eliminated that gun for you. No blood on the holster. The holster was processed. The gun was processed. You heard from experts. No blood on the holster. What does that tell you? An individual who's got blood all over him and no blood on the holster, that holster was put there. You also, please, look at the pictures, if you can. You'll find that there's blood underneath where the holster was sitting. Blood can't go through the outside of a holster, through a gun, through the other side of the holster, through the clip, and onto the shirt, and onto your pants. That's not how blood works. It doesn't go through things. Kind of like how blood doesn't go through a closed door or an open door. Remember that with Cody? Funk. Doesn't know what he heard. That's my recollection of his testimony. He was all over the place. Could have been gunshots, could have been this, could have been that. I hear him all the time. Who knows? And regardless, that was at 9 o'clock in the morning. Medical examiner. No bias. It's true. Also had no idea what was going on at the house because she wasn't there. She didn't process the body. She didn't bag it up. That wasn't her. No clue. No bias, sure. No clue. To insinuate that she knew that the ID was fingerprint scanning is another mischaracterization and misstatement of the evidence. But don't take my word for it. Check your notes. No, this is a good one. The medical examiner testified, this is Mr. Dowdy's argument, testified on that there's a laceration on the top of the finger. Laceration on the top of the finger, the index finger. Great. Where are your fingerprints? On the top of your finger or on the bottom of your finger? Who cares about the cut on the top of your finger? Again, manufactured doubt. GSR on the gloves. There's no evidence that those gloves were anywhere than where they were found, inside Grant's bag. Now, I want to discuss a few things with you. As Mr. Dowdy brought up, getting an instruction about weighing the evidence. And I won't belabor the point. But here's the instruction. It is up to you to decide what evidence is reliable. Please, you should use your common sense, not my words, in evaluating and deciding what the best evidence is and which evidence should not be relied upon in deciding your verdict. Some of the evidence you can find reliable, some not reliable. You can believe part of testimony, not part of some other testimony. Okay? These are the things you consider when you're weighing testimony and evidence. Did the witness seem to have an opportunity to see to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the questions? Did the witness have any interest in how the case should be decided? Number 5 is important. They're all important. Does the witness's testimony agree with the other testimony and the other evidence in the case? Did the witness at some time make a statement that's inconsistent with the testimony he or she gave in court? That's the law that you are to apply. And so when you go back and you go down the list of witnesses that testified in this case, you do that. I want to point out a couple more things about Mr. Amato's story not adding up. These are these notes that were found in their evidence. The notes that were found. There was one note that was found in the hotel room, and there was the one note that was found in the car. Interestingly enough, there were no notes that were found in the house, but apparently Mr. Amato's become quite the diary writer. So let's begin with the one found at the hotel. I miss being home already, and it's only been 1 day since I was kicked out by Dad. Cody said he'd take care of it, but there is nothing he can do about this. I miss the house, and the comfort and the atmosphere had been getting worse and worse. Cody sounded pretty sad, suicide. And I told him that it's over at the house. We had a good 29 years, and I wish it could work out. Looks like I have to finally live on my own. This part's laughable. Sadly, Cody is still helping me by giving me his debit until I can get settled. Oh, and the interview went well today. And no phone service because Dad canceled it. So here we have laying out a suicide, laying out why he has Cody's debit card. I guess he forgot he stole his credit card too. I went to an interview, so I couldn't have been there when it happened. And you can't track me because my phone doesn't work. Now we talk about the suicide note that was in his car that he couldn't drop off. Brother, and remember, this is interesting too. It's written in different person, first person, third person. Brother, they just told me what happened. Dad told you to pack your shit and get out of the house because you were caught texting that woman again. Grant, I'll take care of all your problems. I just need you back. I can't live without you, brother. I said I'd take care of all your problems at the house, and I have. No one will ever bother you again regarding this. Please come home. Can't do this again. I'm part of the problem, and I've really lost you. And I can't take that loss after everything. There is nothing I can say to change your mind. I love you, 022, and I wish you felt the same. It's going to come home after you. It's going to come after you again. Well, what's the point? The defendant wrote this. If you believe that he wrote this to memorialize a conversation he had with his brother, that belief is not reasonable. That belief isn't even forced. I don't know that you can even imagine that. This was the note that never got dropped off at the house because he couldn't finish his plan. I implore you, please, to review the evidence. Review your notes. Look at every single thing. It's like over 300 pieces of evidence in this case. Look at all of it. I want you to. We want you to. To infer that we have manufactured or created a case is discouraging. It's not our job. Put the police on trial for their investigation of a triple homicide. It's fine to a certain extent. You should hold the police accountable. That's what makes America, America. But don't fall into the trap that there's some conspiracy, that everybody's a liar and everybody's incompetent, because there's no evidence to support that. And your verdict has to be based only on the evidence. Thank you.